in our firm, we focus a lot on advanced planning, but every so often it's good to just kind of get a refresher on, hey, why are we even doing these living trusts? What is going on? So hi, this is Jim Cunningham, and we're going to talk about estate planning basics. Avoid probate, save taxes, and protect your legacy. This applies to everyone. If you're really rich or not so rich, all these rules apply in the same way. Okay, the numbers are just bigger on people with more assets. So don't forget about Prop 13 either. So Prop 13 is really important. I know it's really important for many of our clients, and they want to preserve that because oftentimes people just can't afford the property if it gets reassessed. So got to be careful with that. I'm a partner at Cunningham Legal, 25 years experience. We have offices throughout California. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker, and securities and insurance licensed. I'm also a pilot single engine land. These are the lawyers in our firm. We've got a great group of lawyers, and we're focused exclusively on, basically helping families, individuals and families with their estate planning needs and kind of wealth planning needs, if you will. Subscribe to our YouTube channel. This is really important. If you subscribe, it appears in your feed. And then as we release these, and these typically are released weekly at sometime Thursday afternoon-ish. So this is a disclaimer. This is very important. I am an attorney and I'm talking and my lips are moving, and this is not legal advice. So if I say you, I'm not meaning you like there's an attorney-client relationship, but really this is something you do not want to do on your own. You absolutely need expert advice from a qualified and licensed advisors. So we'll go through a lot of these things, and sometimes you have to go to people who have a specific license. So what is an estate plan? Well, if you Google what is an estate plan, you actually hit our law firm, right? So we're the #1 position in what is a California estate plan? Why do I need one? So we say a California estate plan generally includes a living trust, powers of attorney, living will, pour over will, and requires a specialized California estate planning attorney to do it right. An estate plan cannot be created after death. Very important, kind of basic. You got to do it while you're alive. Now, GPT-4, ChatGPT has been in the news a lot. GPT-4 was released last week. And so I asked GPT-4, what is an estate plan? And for those of you who have been asleep, for the last 2 months, artificial intelligence is real. It's here. We're using it in our firm. It makes us far more efficient, and it allows us to help our clients a lot more. Well, GPT-4 says an estate plan is a comprehensive strategy designed to manage and distribute an individual's assets, minimize taxes, and address various personal and financial matters in the event of their incapacitation or death. And I got to tell you, that's amazing. That is unbelievable that this technology can do this. This is fantastic. It's different than a Google search. This actually is almost like a mini white paper, right? It kind of explains it without having to go to different locations. So very important. So what is an estate plan? An estate plan is, as I kind of went through those two things, it's a comprehensive plan. It includes many documents. So primarily when lawyers talk about estate planning and, they talk about clients, the lawyer's thinking about documents. Okay, well, they need this document and that document and that document. The client sees this pile of paper and they're like, what is this? Like, how do I even deal with this? Like, I signed this thing. I don't know. I can't read it. It's not even written in English. So we'll cover the other elements of an estate plan in a little bit, but for now, just understand it partly is the living trust, but there are a lot of other things, and we'll go over that in a bit more detail. So why should you have an estate plan? Well, avoiding probate is a really good idea. For those of you who have been through probate, it can be kind of a living hell. And there's a cartoon here that says they were sad when they found out their wealthy grandfather had passed away, had died in an earthquake. They were devastated when they discovered he had written his will on an Etch-a-Sketch. So that's probably not a valid will, right? An Etch-a-Sketch, think about it. It typically is a piece of paper or pieces of paper, and you get out a pen and you sign your name and it's witnessed. And for those of you who are like, you got to be kidding me, isn't there a digital will? Isn't there some type of technology? We're in California. We do it old school, at least as of the date of this webinar. And yeah, it's got to be printed piece of paper signed. Save taxes. I mean, who doesn't want to save taxes? Paying taxes. Look, this is not tax avoidance. This is not paying what you sort of getting away with not paying taxes, but there are lawful ways to simply, based on structure, to pay less tax. It's not rocket science, right? And protect your legacy. And that's really important. So why have an estate plan? So why have this writing? Because you're living your life. You get up, you go to work, maybe you're retired, whatever it is, and you go, do I really need to do this? Well, one day you're not going to be able to do for yourself. Now, what do I mean by that? Well, some people lose mental capacity. Everyone dies. And if you're the kind of person who says, look, if these people pass away, I don't really care, then don't do an estate plan. But, most of our clients kind of care. And that mental capacity is really important because that is really a slippery slope. And I think we've all known someone or loved someone who's gone through some type of mental decline. And it's really sad. It's happened to my family. It's happened to my wife's family. And that's something that is just, you need to plan for, because it really makes it harder on the people who love you, right? And the people who are going to care for you. So why wouldn't you want to make that easier? And failing to plan really means planning to fail. And, that is really true in the estate planning context. And you'll see as we go through the materials here, all the things that can happen really that are kind of avoidable, right? If you just do some basic adulting, go to the lawyer, sign the documents, maintain it, and we'll kind of go through that. But without an up-to-date written plan, your estate will likely end up in probate court. And a lot of estates, even with living trusts, end up in probate court. And we're going to show you, some basic strategies to keep that from happening. That's very, very important. And an up-to-date plan keeps you and your loved ones out of probate court. That's the idea, to keep it up to date. And in California, we start with the revocable living trust as really the foundation of the estate plan. It's not true in every state. So if you're watching this in another state and you go, well, I talked to this expert lawyer and that lawyer does not recommend a living trust. Living trusts are valid in all 50 states. And I talk to practitioners in other states that say, in our particular state, people just aren't used to using living trust. We go through probate. Well, one problem with probate is it's all public. So if you want to keep your matters private, look at a trust. But I would say in California, probate is so crazy, you just want to stay out of it. It's very expensive. So again, another reason to have an estate plan is people who have Prop 13 protection, they love it. And this is a really big deal. If you're rich or poor, it's a big deal. If you own property, you want to keep that Prop 13 protection. Unfortunately, Prop 19 took away a lot of the parent to child reassessment exclusion strategies. It gave us tremendous planning opportunities for people 55 and over who are going to move a residence. Now you can move that tax base to a new residence in California. There's some conditions. We do cover that in other webinars on our YouTube page, so I'd really encourage you to check that out. And you can create a plan to preserve your Prop 13 protections. And this, I will say though, this is a niche area, meaning I'm in a subspecialty that has about 7% of lawyers do trust and estate law. So we're already a very small niche. And maybe 1% of those lawyers maybe understand this. Okay, so this is a niche within a niche, and it's a very small group of lawyers in California who understand this. We have clients all over the state because they just can't find an expert in this field. So if you're really motivated to preserve Prop 13, there are planning strategies that you can do to preserve that for your family. It's very important. So the living trust, how do trusts work? So you've heard about the living trust. This is an example, Helen Wanda Lopez. This looks really complicated, and it is. So this is technically what happens. This is sort of the flow of, they create the trust, one passes away, then the other one passes away, and all this stuff you have to do. But really, why would people go through all of that hassle? People go through this primarily, it's just peace of mind, right? You want to make sure your stuff is set up. And I think that's a really big motivator for people, is they want to make sure that, when you leave this earth, as we all do, it is the price of living, right? We do leave this earth. And, the people you leave behind, the loved ones you leave behind, you don't want to leave a mess, and you want to have peace of mind that you've done what you should do on the limited time that, we all have on this earth. So it's part of, people use trust for estate planning, for tax planning, and for asset protection. Asset protection for inheritances, not so much asset protection for yourself. You can use those, but when we say asset protection in this context, we're talking about protecting your legacy after you're gone. Or maybe while you're still here, if you make a gift, a lifetime gift, right? So trusts, obviously, they avoid probate, and they can minimize taxes, and they provide a structure, a platform to manage your assets. And they are, in California, the core of many plans. So remember this, I'm not going to walk you through this complexity because you guys will fall asleep. Maybe I should do one, and you can listen to it if you have insomnia, because it will put you to sleep going through all the technical stuff. What I'm going to do is I'm going to make this really simple. Okay. A trust is like a bucket, right? It's got a handle. Inside of this bucket, the trustee, that's the person who's driving, like driving a steering wheel, holding the handle. The trustee is the one who is in charge of the trust assets. The trust is the bucket. And what you do is you put your house, your stocks, your bonds, your mutual funds, your rental property, whatever it might be, you put that into your living trust bucket. You're the trustee. You hold this handle. You're in charge, right? If something happens to you and you die or become incapacitated or whatever, that bucket passes to the successor trustee. That's a trust. That's a living trust. That's really what we're talking about. Not this whole complicated stuff. I mean, that's important, but that really, this is conceptually like, what are we even talking about? We're talking about a bucket with a handle, and the trustee holds that handle and passes that to the next trustee when you stop being trustee. Now, you might still be alive. Well, that bucket would be used for your benefit. When you die, you can't be a beneficiary. Dead people can't be beneficiaries. And that's who is entitled to all the good stuff. Bene, meaning good, so you can remember it. That's a person who's entitled to all the good stuff in the trust. So the trustee dips into that bucket and, gives some money to the beneficiary, pays some of the beneficiary's bills, buys a house for the beneficiary, whatever it is. But trusts have to have three things. A trust has to have a trustee, that's a person, has to have a beneficiary, so it's another person, could be a charity, and a corpus, and that means the body of the trust. It's the stuff, right? The house, the stocks, the bonds, mutual funds. And many of you, if you do a trust with a lawyer, you might, when you look at your trust, you go, oh, it says Schedule A, $10. What, do I have to put a $10 bill in here? Well, that is really the corpus. So when you create a trust, you may not be putting your property into the trust on that day. You certainly probably aren't putting your bank accounts in that day, right? So we do have this recitation of considerations, what lawyers call that. So trusts take care of your assets while you're living. Ideally, they're designed to avoid probate at death and probate during incapacity. So this is very important. I would say in the hierarchy of importance, this might be slightly more important than the problems you go through at death, because when a person becomes mentally incapacitated, not only does the trustee have to use those assets for the benefit of the person who created the trust, they also typically have to take care of that person. So many times the successor trustee is the person who's taking care of the physical well-being of that person. And, I can tell you from personal experience, my wife has been the one who's had, significant portion of the laboring oar in caring for her aging parents. And it's a lot of work. And I wouldn't underestimate that. So if you've been asked like, hey, mom and dad want to name me as trustee, there's a lot to do. It's an honor, but there's also a lot to do. So, make sure you're on board with that. There's some little used strategies to protect your beneficiaries, the people who inherit from divorce, taxes, and lawsuits. A lot of attorneys know about this and they don't do anything. It's one thing not to know, right? But if you know and don't do, it's kind of like not knowing. And so I know many lawyers I talk to, they go, well, yeah, it seems like, I don't know why they don't do it. But this is something that I'm concerned about personally in my own family is, I spent my career working hard, helping clients, and my material wealth, when I'm gone, when I leave this earth and it goes to the people that I love and care about, I want it protected because, things can be taken away in divorce, things can be taken away in lawsuits, but I would say divorce is the single biggest threat. So meaning a child inherits assets and then later gets a divorce and it's split up. Many people, wouldn't want that. Something else to understand is a revocable trust. What is that? That is a trust that can be revoked, meaning you can take it away. You can pull all the assets out of the bucket, put them back in your pocket. That means that trust is also amendable. You can change that in the manner provided in the trust. This is very important. So if you say, hey, I want to change some stuff in the trust, it's a really bad idea to write on the trust. Okay. Generally, right? You want to look at the process to amend the trust. And typically it's going to be a subsequent writing or an additional writing later in time that is signed by the person who has the power to amend the trust and the trustee. So that's a very common provision in a trust. An irrevocable trust, these revocable trusts become irrevocable typically at death, meaning they are not subject to amendment or change. And it's kind of set in concrete, right? If that makes sense. So let's look at an example of a living trust. And we have Hal and Wanda, and we're using a husband and wife, and just to H&W, husband, wife, just to keep it straight in everyone's mind. And they're spouses, and they want to create a living trust. Hal and Wanda create this trust with a bucket. They're holding onto the handle of the bucket. Hal and Wanda transfer their home and rental property by deed. That's how you put property into a trust. You don't just say on your schedule of property, my house is in my trust. I declare that my house is in my trust. Guess what? That's not enough, because when we go down to the county recorder's office, right, and we see who's on title to that property, if it's Hal and Wanda are dead, it's too late for Hal and Wanda to sign that deed because they're dead, right? So you need to make sure that Hal and Wanda have transferred, or Hal and Wanda would want to make sure that they've transferred that asset to their living trust. And the title will often read, and I'm contrasting what a deed says and then what a bank account says. So I know this may be a little granular, but it's very important to understand this. You have to have a deed, and it's going to say Hal and Wanda Lopez, trustees or successor trustees of the Lopez Trust dated March 23rd, 2023, and any amendments thereto. That is in the deed. And the reason all of that's in the deed is that what's recorded is the only thing. There's no other context. So deeds, something to understand is deeds lack context, meaning there's no other information other than that information recorded when we go to the county assessor to pull that deed. So I will tell you, in the real world, what has happened, sometimes if it doesn't say successor trustee, you might have a problem with title, typically not so much. But this is the kicker, and any amendments there too, because remember, this is a revocable trust. And we have heard of situations where if you just say the trust dated March 23rd, 2023, and then later amend it, the question is that property owned by which trust, what controls? That can make some title companies nervous, and it can kind of delay the progress of the trust administration. And we'll talk about what trust administration is a little bit. Bank accounts typically have a shorter name. And so it'll say Hal Lopez and Wanda Lopez, trustees of the Lopez Trust dated March 23rd or 3/23/23. And the bank may ask who the successor trustees are of your trust. So this is very interesting. They used to not ask this, but now they want to know that when Hal and Wanda aren't trustee and somebody shows up at the bank saying, I'm trustee of Hal and Wanda's trust, how does the bank know that that's not just a fake document, right? So now they're starting to ask for who the successor trustees are, which then begs the question, if you amend your trust and you change your successor trustees, it might be a good idea to notify your institutions that you change your successor trustee if they've asked that in the past. So you can see it's kind of complicated and it gets really kind of dense here pretty quick, but I just want to give you an overview of the importance of paying attention to detail on your living trust. And you can transfer your brokerage accounts, LLC units, stocks and bonds. If you have a rental property in an LLC, you're going to want to make sure the shares of that LLC in this context are in the living trust. Not IRAs, life insurance, or annuities. Very, very important. IRAs, life insurance, and annuities are not put into the trust during the lifetime of Hal and Wanda. Those are held in Hal and Wanda's individual name. So let's talk about life insurance. What do Hal and Wanda do with the life insurance? Well, in this case, Hal is named Wanda primary beneficiary. What does primary beneficiary mean? It means when Hal dies, if Wanda is living, she is the beneficiary, primary beneficiary. We might name the trust secondary beneficiary. What does that mean? Well, that means if Wanda's dead, that death benefit goes to the trust. Okay, very important. The IRAs say Wanda. Hal leaves his IRA to Wanda and then to Sam and Deb equally. Sam and Deb are son and daughter. You can see why we use H&W and S&D. So Hal dies, leaves his IRA to Wanda. She does a spousal rollover. And then when Wanda passes away, she leaves her IRA to Sam and Deb equally. Individuals, this is human beings with a heartbeat, not dead people, not trusts. Typically, sometimes we use a trust. Hal removes his ex-wife as beneficiary. Very interesting. What if Hal had a prior marriage and his marriage said the ex-wife is no longer legally a beneficiary, but if Hal never changes his beneficiaries, guess what? When his ex finds out, when Hal's ex finds out that Hal's dead, the ex is going to want to get a death certificate and race down to that institution and claim the money. And they very well may pay it. Now, is that underhanded? Is that cheating? Is that whatever it is? Yeah. I mean, it's not right, But that can happen where X's can end up with beneficiaries. So typically there's an order in a California dissolution, which is a divorce, that says that those people are no longer lawfully the beneficiary, but sometimes they're on there anyway. So 401k, Wanda is what we call the primary beneficiary by statute under ERISA, and then Sam and Deb 50-50. But what if the ex-wife is on an old 401k? Same problem that we had with the IRA, right? Annuities, and I'm talking about a non-qualified annuity. By the way, when you see the word qualified in the context of estate planning, that means tax qualified. It means there's some there's some attribute of an annuity, or there's some attribute of whatever it is that has some tax benefit for a taxpayer. That's what qualified means on a very high level. So what we're talking about are non-qualified, not in an IRA. These are tax deferred annuities, but they're not in an IRA. Hal is the owner and the annuitant. Wanda is a beneficiary. We really caution our clients in naming a trust as a beneficiary of an annuity. You have significantly fewer options when it comes to stretching out payment. Certainly if, and spouses have better arrangements than non-spouses. If, Hal leaves the annuity to a child, it's much better if it's a spouse and then the individual people. And on IRAs, sometimes we use a standalone trust for an IRA. It's a specialty trust. And with Secure Act 2.0, that's really changing the landscape. And that's something that, we're working on clients with now. So you have your living trust, but wait, there's more. We're going to talk about the pour over will, the nomination for the guardian, the durable power of attorney, HIPAA, and advanced healthcare directive. A pour over will is a will that says whatever I own at my death pours over into my trust bucket, meaning if I have a house that's in my name and I die, that house goes by will to my trust bucket. Now, I got to go through probate, but at least it's going through that single planning mechanism rather than going to my intestate heirs, which we'll cover a little bit later. Guardian nominations for minor children. There are two ways to do it. You can nominate your guardian in your will, but your will is technically not a legally effective binding document until a probate court, right, who's a probate judge, has said that it is a legally binding document. It is evidence of your intention. And many clients who have minor children, there's a standalone single page form that is a statutory form in California where you can designate who the guardian of your children might be in the event that you're not able to perform your duties as a parent, meaning you're passed away or you're incapacitated, right? You get hit by that ice cream truck, but don't die. Durable power of attorney for property. That is where you say, I give to this person the ability to stand in my shoes and take actions on my behalf. So this is different than a trust, and we'll talk more about that in a little bit. But a trust is, I'm putting assets into this trust. The trustee shall administer these assets that are in this trust only in this particular manner. A power of attorney says, whatever happens to be in my name, IRAs, 401ks, annuities, life insurance, registered mail, whatever it is, that agent under the durable power of attorney will act on my behalf. That can be significantly broader authority, quite frankly, than the trust. It can be a much shorter document. So durable power of attorney, we typically counsel our clients to consider this. Most people do them, but it's a very powerful document and you really need to pay attention. You need to have a really trustworthy person in there because there's no court supervision, no court oversight. They still are acting as a fiduciary. There's no court oversight. So it's very important to pick a trustworthy person. HIPAA authorization and advanced healthcare directive are kind of like peanut butter and chocolate. They go together. The HIPAA authorization says I grant my spouse to access my health records, even though I'm not incapacitated. And the advanced healthcare directive says, if I cannot articulate my own medical wishes, then I designate this other person to make medical wishes for me. That's a legal document. It's not really directing care as much as it is empowering another person to make those decisions. You can have some guidance in the advanced healthcare directive. I would contrast that with a POLST, that pink sheet that sometimes people put on their front door, maybe in assisted living. And that POLST form is a physician's order regarding life-sustaining treatment. That's the thing that says, if I'm choking on a peanut, don't give me CPR, right? Don't give me the Heimlich maneuver. Don't do anything because I've got congestive heart failure. I mean, I don't, I'm saying hypothetically. So that would be somebody who would not want to be, would not have those measures done. And the EMTs, when they show up, they see the POLST and they go, okay, no, it's a DNR. That's not advanced healthcare directive, a little bit different. How many kinds of trusts are there? Well, I came up with 31. There's probably more. And kind of like ice cream. 31 flavors. The revocable trust, we talked about that. Irrevocable trust, a revocable trust can become an irrevocable trust. And there is a whole universe of irrevocable trusts that are used in planning for a variety of reasons. There are special trusts for life insurance. If you have a loved one with special needs, you might hear about a special needs trust, or in other states other than California, a supplemental needs trust. In California, it's a special needs trust. Standalone IRA beneficiary trust. Sometimes we use a trust for retirement accounts. Sometimes we don't. It just depends. Q-tip trust, bypass trust, dynasty trust, meaning you want to leave something to your kids, and then when your kids pass away, it goes to your grandkids. But that transfer from your kids to your grandkids is tax-free, kind of cool. So that grows for a whole nother generation. It's a dynasty trust. A SLAT is a spousal lifetime access trust. And we've got some information on that on our YouTube page and I believe our website. And a qualifying domestic trust or qualified domestic trust. That's very important. So if you're a non-citizen inheriting from a spouse, you do not have what we call an unlimited marital deduction, meaning I could inherit from my wife $1 billion. If she was a billionaire, I could inherit that. I don't pay any death tax. But if I'm not a US citizen, I get to pay death taxes on that, okay? Or her estate pays death taxes on that. So that is a workaround for a tax deferral. The bottom line is if you're a non-citizen and you're like, oh, I'm a non-citizen and I might be inheriting a lot of money from my spouse, or maybe we're both not citizens, it gives you the opportunity to become a US citizen, right? And get around that tax bill. So very, very important. And qualified subchapter S trust, very important. And the very important if you have any subchapter S stock, you don't want to tick off your other the other shareholders. If you don't have that in your trust, it can create a real problem for the corporation, for the S corporation. So when are trusts activated? When are trusts activated? What am I talking about? I'm talking about trust administration. I'm talking about I set up a trust, I get hit by the ice cream truck, and I don't die. There I am in the hospital, tubes coming out. My bills have to be paid. Stuff has to happen. Who's going to do that? Well, while I'm trustee of my own trust, things are quiet. It's all quiet on the trust front, okay? Nothing happening, no drama, no extra work. It's not a big deal. Pay my mortgage, live my life. But when I stop being trustee, that's when things start to happen. It's especially if I'm incapacitated or deceased. So sometimes people resign as trustee, but they're fully capacitated. We don't see that much. Typically it's incapacity or death. That's when trust administration begins. Now, trust administration is a horrible word. I did not invent this. I did not create this. It's terrible because it doesn't mean anything, right? It is the process of managing a trust according to the terms and carrying out the grantor's, the person who set the trust up, instructions and managing the trust assets. Examples are going to be collecting income, making distributions, filing taxes, and preparing and filing legal documents. That's kind of the basic element of making investment decisions that a trustee does. Trust administration can be extremely complex, okay? And it's important to have an expert lawyer guide you through the process. I would really recommend if you know, and this is something we offer in our firm, is call us. We can set an appointment. You're going to pay a little bit of fees to sit down with a lawyer or watch a lawyer on Zoom, right? As the world is now, and go over, hey, do you need a lawyer for this? Or what are the problems that are coming up? Because some trust administrations, frankly, I'm not sure there's a lot of attorney involvement. There's stuff you have to do. Others are wildly complex. And, you know, we cover this extensively on our YouTube page, but this is really important. If you're a trustee, you have 100% personal liability. The stock market went down in 2022 a lot. Trustees who did not have appropriate documentation are personally liable for stocks going down, okay? But there's a way you can mitigate that by proper legal counsel and proper trust administration. So very, very important. So here's a tip. People often get trustee and beneficiary confused. What's the difference? Well, the trustee is a person driving the bus and the beneficiary is the one on the seat in the bus, okay? So the trustee's driving, the beneficiary is along for the ride. That trustee's got to look out for traffic, got to make sure not hit the pedestrians, keep that beneficiary safe, driving the bus. The beneficiary can be a jerk. The beneficiary can be in the back yelling, harassing the bus driver, throwing stuff at the bus driver, making faces, you know, just being a jerk. And the trustee has to maintain his or her professionalism. So That's the kind of difference between a trustee and a beneficiary. But what's better? Is it better to have duties or rights? Yeah, it's probably better to have rights, okay? Because these trustees have so many duties. These duties are written, they're unwritten. So we have the trust. You have to follow the terms of the trust. You have to follow California law. And that California law, many times, is not written into the trust. It's just not there. But you as trustee have to know that. That's why I hire a lawyer to say, look, in this case, in your particular case, these are the things you need to watch out for. And really, that's why you're hiring a lawyer, right? Is to watch out for all the stuff that can go wrong. And then you have case law and doctrine and all these other things that are just, the bottom line is a beneficiary can be jerk. A beneficiary can haul a trustee into court, can file an action in court. Many of these actions are not considered contests to the trust. They're actually viewed as enforcing the terms of the trust. But again, beneficiaries can be jerks. Trustees have to maintain their professionalism. So we have one more question I want to get to before we start on why are these things so long? Anonymous asks, can you please discuss a little bit more about what you would recommend with regard to life insurance? You mentioned not putting it in the revocable trust. When do you put life insurance in a trust? Oh, in a life insurance trust. Oh, you put life insurance into a life insurance trust if you want the death benefit to be outside of the owner of the policy's estate. So if I have, which I don't have, if I had $100 million estate, I'm not sure I'd be doing this if I did. If I had $100 million estate and I had a $10 million policy of life insurance, I would want that $10 million policy of life insurance outside of my estate to save the 40 or 45% death tax. And that's why you would put it into a life insurance trust. The break even on that is, when your estate's about 5 million, depending on your age, you need to start looking at that. I would say that's when people start looking at it, when their estate's about 5 million. Brody asks, if my husband and I set up a trust and we are co-trustees and one of us gets incapacitated, but the other is fine, trust administration doesn't begin, right? Only once both of us are dead or incapacitated. I mean, Brody, that's a good question. It really depends what's community, what's separate. It depends on what your trust says. But I would say, yeah, I would say this sort of trust getting hot, getting active really happens when when the people who are the beneficiary aren't the trustee, right? If that makes sense. So Margot asks, can the beneficiary of the trust and the successor trustee be the same? Yes, absolutely. So Margot, you can. There's no requirement that they be different people. Well, why are living trusts so gosh darn long? Why is it law by the pound? What in the world is going on here? Well, here's the thing. Trusts are long because they have to communicate legal rights, obligations, and responsibilities without involving a court. And it should stand alone, meaning it should give your successor trustee, this is the person who's going to be acting and carrying out the terms of the trust, clear instructions, enough instructions, clear instructions, and proper authority. That's very important, the authority to get the job done without having to go to probate court. And there are a lot of what ifs in there. What if the person you name to handle your affairs when you can't refuses to serve? There's no requirement that they serve. I mean, if they do start serving, they've got a lot of duties, right? But there's no requirement that they serve. What if they pass away? I mean, this is kind of one of the most common issues is, hey, we've run out of trustees. What do we do now? What if you don't die right away and you lose the ability to make decisions for yourself? I mean, there's a lot of what ifs. We need to address that. How do you want your money spent? Do you have any obligation to support? Whatever it is, it's got to be written into the document. And what if a 14-year-old inherits more than 5,000? That's kind of a problem, because if that 5,000 is the number where if that 14-year-old has 5,000 in property, the law says you have to open up a guardianship of the estate, even though they have parents. But there are ways to draft around this. So, by the way, if it isn't in the living trust, if these terms aren't addressed in the living trust, it's likely that people end up going to probate court. So I asked GPT-4, why is a living trust so long? Man, this is good. I got to tell you, I'm very impressed. A living trust is often a lengthy document because it meticulously outlines the specific terms and conditions related to the management, distribution, and control of an individual's assets, while also addressing various contingencies to ensure a smooth transfer of property and minimize potential legal disputes. I could not have said it better myself. This is not a replacement for lawyers, but this is a fantastic tool, and I'm very excited. The importance of properly funding a living trust. This is the care and feeding. And so, you do your trust. Now what? What's next? I barely understood what the lawyer said. And now I got to do a bunch of stuff. This is all very confusing. Well, I'm going to unpack this for you. You do have care and feeding. Remember, a trust is like a bucket. There's a handle. You're the trustee. You're holding onto that handle. You have a bucket and you have to put your assets in there, right? This avoids probate. It maintains privacy. Remember, probate's public proceeding, right? The amounts are public. Who's inheriting? All this is crazy public information. I mean, I am shocked that lawmakers haven't fixed this, because the date someone's getting an inheritance, the amount, the circumstances. It's kind of a lot of information. Efficient management of assets during incapacity does require care and feeding. Now, what do I mean by that? Is this trust has to be funded. It's very important. Funding means assets titled in the name of the trust, titled in the name of the trustee of the trust, and to minimize estate and death taxes and ensure a smooth transfer of assets to heirs. By the way, death tax has been politicized. When I use the term death tax, I'm encompassing generation skipping transfer tax, estate tax, and state death taxes. California does not have a state death tax per se, but others do. And so that's why I'm using the term death tax. Now, without proper funding, a living trust cannot fully achieve these objectives and can result in serious, unnecessary legal, and I'll put this in quotes, complications. Translation, lots of attorney fees, okay? Lots of work. I'm not just charging fees to charge fees. There's a lot of work to be done. And significant delays in asset distribution. What I've seen in the last 25 years of practice is many people, when they inherit, they're inheriting their retirement. And their parents are living a long time. And you may not inherit until you're in your 60s or 70s, and you really need that money. And that's kind of what you're, kind of you're banking on, maybe, is your retirement. And, if it's delayed 2, 3, 4 years, that's a real problem. So funding your trust, key takeaways. Unfunded or underfunded living trust can be subject to probate court. If all that stuff's not in the bucket, you may have to go to probate court to get a judge to sign an order to put it in, because if something is in my name and I'm dead, I can't sign anything because I'm dead, right? Someone else is going to have to do it. And if my name's the only name on there, by the way, durable power of attorney expires or ends at death. A living trust continues on, but that durable power of attorney ends. So you cannot use that power of attorney to fund a trust after death. Delays the administration, higher fees and court costs. The trust becomes public. The trust itself becomes public record. Now there's some things you can do to potentially seal a court record, but bear in mind that trust is public record. And this is interesting, personal property list. So a lot of people, they say, well, I'm going to take this piece of china and I'll write Bobby's name and I'll put a sticker on it, and I'll kind of mark people's names on everything. I've heard that. What we do in our office is when you have a living trust centered estate plan in our office, there's a section in the trust that says, in this plan, there's another area where a person can handwrite. It's not in the trust itself, it's an attachment. And the person can handwrite who gets what. So I'm going to leave Johnny my whatever it is, my tools, and you just write that in. And that seems to get the job done. Not necessarily involving a lawyer. That's really one of the only places you can write on your estate plan. And I would suggest this is just something to think about. You're typically going to name human beings with heartbeats as death beneficiaries of your IRAs, 401ks, and annuities. This means a person who's alive, not a dead person, and not, right? You're typically not a trust unless your IRA legacy trust is appropriate. Is not that IRA legacy trust, by the way, is not a living trust. It's one of those 31 kind of other trusts, but sometimes that is appropriate in certain circumstances. But I think this is where, and lawyers get tripped up in this quite a bit. A lot of lawyers, I don't think, have sufficient training on planning for IRAs and 401ks. And if you ask them, if there was an attorney next to me, the attorney would say, yeah, attorneys don't have enough training on this because it's not law, it's financial services. And it's kind of this is where the crack or the border or this space between estate planning, between lawyers and financial advisors that lawyers don't know enough about, but frequently are giving advice without adequate training, unfortunately. So we have a question. Aaron asks, how expensive is it typically for an estate to go through probate? Do you have a ballpark figure? We're going to get to that. Ron asks, should digital assets be included in the trust bucket? How is this typically done? Yeah, Ron, great question. This is kind of a hot topic. The trust assets. or the digital assets, and it's a moving target. We do have a recitation in our trust about digital assets, and typically that's enough to get us what we want. Crypto is a whole nother world, though. What if there's no estate plan? There's no will, there's no trust. What happens? What if you can't find it, right? What if it was never done? No estate plan means you're going to probate. No will is called intestacy, without a testamentary document, lacking this last will and testament. Is a will a complete estate plan? No, a will is a will. What about the power of attorney for property? What about the power of attorney for healthcare? What about all these other things? Is a will enough to avoid probate? No, a lot of people think that a will is enough to avoid probate. And probate is a legal process administered by a probate court judge to prove the existence or non-existence of a will. So what do I mean, prove the non-existence of a will? It's like, wow, that's really out there. Well, a person files a petition for probate and they say there is no will, and there's notice that goes out to the world. There's publication. You have to publish it in a newspaper. I'm not kidding. Literally a newspaper that's printed. And people have the opportunity to come forward and say, oh, there was a will, there wasn't a will. And then a judge can say, well, there was no will. And then we're gonna divide the property accordingly. You have to do a probate in every state where property is owned, okay? And so the example here, Dan dies a resident of California and leaves a last will and testament. Dan owns a home in LA, a vacation property in Oregon, and an apartment building in New York City. 3 probates are required. The first one starts in California. The Oregon and New York probates are going to be what are called ancillary probates. New York is the other pain in the neck jurisdiction when it comes to probate, okay? Who gets what? Let's say Dan dies. Who gets it? Does it go to the state? Does it go to King Henry VIII, who's the creator of the Statute of Wills? The Statute of Wills, I think 1508, as a way to say, oh, you didn't have a will, then I get it. That's how he got, a lot of land. So, but California laws of intestacy work just slightly differently. They are not exactly easy peasy lemon squeezy. And let me walk you through this. So this is a little bit like the LSAT. So just empty your mind a little bit. I'm going to give you some sequencing. Okay. Dan marries his spouse 3 years ago. Dan has a son and a daughter from a prior marriage. So Dan marries a spouse. He brings 2 kids along. 2 years ago, Dan's son passes away, leaving no children. So now it's Dan, Dan's spouse, and Dan's daughter. This year, Dan dies, survived by the spouse and the daughter. Who gets Dan's stuff? Who gets the New York City? Of course, that's probably decided under the laws of New York. That's an example of a conflict of law. But in California, what would happen? Well, all of Dan's community property goes to Dan's surviving spouse. Half of Dan's separate property goes to his spouse, and the other half of the separate property goes to the daughter. Had the son survived, the spouse would have gotten all of the community property and 1/3 of the separate property, and the kids would have split the other 2/3. And if Dan had 10 kids, it would still be 10 kids splitting those 2/3. So what's community property and what's separate property? Good question. Totally outside of the scope of what we're talking about. We cover it in other webinars, but here's the problem. We have to figure out what's community, what's separate. Was Dan working? Was he not working? Did he take those wages and improve a property? Did he pay down a mortgage for those wages? This is all this math that starts happening, and you put lawyers and math together. I'm just telling you, you're going to get an uncertain result, okay? Because lawyers, the reason they're lawyers, because they're probably not good at math generally. So that's a tough one. Dan really should have an estate plan. Okay. Bare bones estate plan. Let's look at a bare bones estate plan case study. Harry never sets up a comprehensive living trust centered estate plan, has 3 children, Abel, Baker, and Charlie. All right. Again, just empty your mind. This is a little LSAT-ish. Harry has 3 kids, Abel, Baker, and Charlie. Abel dies before Harry, leaving 2 children that are minors. So there's Harry, and then Abel dies, and now it's Harry and Baker and Charlie because Abel's passed away and the 2 grandkids. Baker gets divorced and is having gambling issues. Charlie's been disabled since childhood and has no income source and relies on government benefits. Harry dies without a comprehensive plan to address people dying out of order, which happens. And if you're watching this, it's probably happened in your family. Lacking inheritance protection, right? What about Baker and Charlie, who has special needs? So Abel's kids will inherit, but then we have to open a guardianship of the estate for the kids. Baker eventually is going to blow through her inheritance, and right when it could have been protected. And then Charlie is going to potentially lose his needs-based public assistance benefits by having inherited from Harry without a special needs trust. And that's in California, special needs trust. What is probate? What is probate? Probate's a process, okay? You go to probate court. It's a legal process after death or during incapacity, and it involves a court. Trust administrations can end up in probate court. Guardianships and conservatorships happen in probate. Powers of attorney, if an agent under that durable power of attorney goes off the rails and starts, stealing money, a probate court can remove that agent under the durable power of attorney. So probate court has what is called exclusive jurisdiction over these matters. And these are not heard in a normal civil court, and they're subject to probate's quirky rules. So let's talk about probate. I'm not going to go through all of this with you. There are a lot of steps in probate. Some happen concurrently. Some are consecutive. Some have to be finished before the other one can start. And it's the lawyer's job. And by the way, if you are facing a probate, I would really recommend that you contact a very knowledgeable lawyer, not just any old lawyer, but you should contact a person who is either a certified specialist in estate planning, trust, and probate law, or someone who's really knowledgeable, because some states don't have that certification. I'm a certified specialist. I'm telling you, there are so many quirky, weird rules when it comes to probate. You really do need an expert. But when you look at this, what is at the very end? So we're starting on the upper left-hand side and ending at the lower right-hand side. Distribution of assets is at the very end. So you're not going to get your inheritance until this thing's over. Okay. Now there's some exceptions here and there, maybe early distribution. What a lot of people end up doing is they get an advance on their inheritance, which is a really hard money loan. Like there's a hard money loan and a really hard money loan. And they cannot charge exorbitant interest rates, but they can charge you fees. And those fees are very high, and they tend to equal exorbitant interest rates. So I would say this is an area for caution. If you're looking at an inheritance loan, read the fine print and maybe look at some other sources of borrowing other than the advance on the inheritance. Sometimes you don't have a choice. I get it, but it's a very expensive loan, effectively. So probate's a big hassle. Now, they're expensive. Having only a will in place subjects your state to probate. And California has this, what we call formal, and lawyers use this. It's not in the code, but lawyers will say, oh, it's a formal probate or it's an informal probate. A formal probate is like this, 16 to 24 months. We just concluded a probate that went on for about 30 months, kind of a disaster of a probate. I mean, not the person who handled the estate, but just a very difficult situation, a lot of properties in various states of disrepair. It used to be 16 months. I don't even know if 24 is accurate. I'm hearing some counties in California, when you file a paper with the court, you're not getting a hearing for maybe 8 months. I mean, it's crazy. Before COVID, this never, 2-3 months maybe, but 8, come on. Probate fees run a percentage of the estate. It's a percentage of the fair market value of the assets. What do I mean by that? Well, if you have $1 million home and you have a $900,000 mortgage, most normal people would say that's a $100,000 estate. But lawyers aren't normal people. They're lawyers. And a lawyer would say, oh, that's $1 million estate with a $900,000 debt. It's $1 million asset. What do you think the fees are based on? 100,000 or $1 million? The equity or the value? They're based on the fair market value. Those fees are going to total the attorney and executor fees, 50,000. In this case, the probate fees are 100% of the estate, right? So it's the net value that people think about when they inherit, but the fees are fixed on the gross value of the assets without any consideration of the debt, okay? So what kinds of assets are excluded from probate? Well, living trust assets. That's why people do a living trust. It avoids probate, and the trustees are in charge of the assets. IRAs, 401ks, and annuities pass outside of probate. What do I mean by that? Well, I have an IRA. When I die, somebody's going to go to that custodian, that company, They're not going to look at my living trust. They're going to go to that company and they're going to say, Jim's dead. Here's Jim's death certificate. Who gets the money, right? Because the institution has a record and it says, oh, when this person or these people show up with Jim's death certificate, we will write them a check. That's how it works. So it's very important to understand. A little kind of Captain Obvious stuff, but I think people forget this. It doesn't matter what your trust says. It doesn't matter what your will says. The first place as a lawyer we go to when it comes to IRAs, 401ks, and annuities, we don't even look at the documents. The first thing we do is contact the institution. And we ask them, okay, this person's passed away. Who's the beneficiary? Who gets it? Life insurance, same way. Death benefits are paid directly to named beneficiaries. It could be the trust or an individual that are of record on that institution. So it's very important. You need to, maybe test the institution. If you have a life insurance policy or IRA, just ask them, hey, if I died, who gets this, right? Joint tenancy property. This is kind of an interesting one. This can be real estate, bank, or investment accounts. But what if let's say me and a friend buy a piece of property and we go on title as joint tenants, and we're making payments. Maybe the rents are coming in. We each put a little bit down. If I die and my co-owner gets the property, because that's what joint tenancy is, last man or last woman standing gets the property, what's my wife going to say about that? She's going to be like, wait a minute, where's my half? I was supposed to get Jim's. I have this trust. It says I get this. You can see a problem. So you really need to pay attention to joint tenancy property. Sometimes we use joint tenancy for property tax purposes, very esoteric reason to do that. But bear in mind, joint tenancy can have an unanticipated consequence. You just need to know what you're getting into. Get good legal advice. That's something we can help you out with. Community property with right of survivorship on deed. What is that? My wife and I buy a property. It's community property. If it does not say with right of survivorship on the deed, if it says Jim and Lori as community property and I die, Lori, my wife, is going to have to go to court to clear title to sell that property. Okay. Now it's a single court hearing. It's a spousal property petition. It's a different probate process. She still has to go to probate, but community property with right of survivorship goes automatically to the surviving spouse. In California, since marriage equality passed in California, this is married or the term spouse and registered domestic partner is interchangeable. It means the same thing. So if you're looking at a statute and it says spouse this and spouse that, if you are a registered domestic partner, it's interchangeable. Transfer on death deed avoids probate, totally open to all, subject to Medi-Cal recovery. And there's one case I've heard of. I don't know what the case is, but I remember seeing it years ago. A bankruptcy judge in a situation similar to this, where it was of record that this person would inherit when this other person died. That bankruptcy judge ordered those parties not to change that deed, not to change that instrument, so that when that person died, the person who was receiving the property, that went to their creditors under the bankruptcy order. So these came out a few years ago. They're subject to Medi-Cal recovery. So this really affects poor people. I mean, this is a total ripoff. So I would just really avoid these. Definitely get legal advice before you do a transfer on death deed, with the exception of, I would say, I don't know, maybe this is a little bit of humor, a contaminated mine property or a timeshare, a deeded timeshare. So maybe you can do a transfer on death deed to somebody if you don't want to deal with that property. But I say that in jest. I'm just making that up. Payable on death or transfer on death deed. This is where when I die, this person gets it. And you might, payable on death says Jim, POD, Sally, or whatever. I don't know, somebody else. That transfers at death. That is not a probate asset. Again, spouse may not like it. Small estates, if there's no real property in California, if it's not real property, if it's just cash, marketable securities, that sort of thing, if it's $184,500 or less, there is no requirement for a full-blown probate. You can deal with it by affidavit, provided that 40 days has elapsed. Noah was on the ark for 40 days. Jesus spent 40 days wandering in the desert. And apparently you got to wait 40 days after somebody dies to make this small estate affidavit. I don't know why they picked 40. But here's the wrinkle. Nevada is 20. So what if you have an account? Let's say you live in California, and I live in California, and I have a $100,000 account in a bank, and I might have a $30,000 account in Nevada. I can't use a small estate in for that account in Nevada. I can't use a small estates affidavit. I might have to start a probate in California just to get that 30,000 for in Nevada. So it's really very important. You need to take these assets like brick by brick, asset by asset, account by account, and really look at them with your lawyer. I mean, this is what we do every day helping clients. And yeah, so this is the example of having a non-spouse get the other half of the property. What do you do if you need to go to probate court? This is very important. If you're watching this and you're like, oh my God, mom died without a will or with the will, I got to go through probate. This seems like a total hassle. This is very depressing. Not all lawyers are the same. You should seek out a lawyer. I mean, this is kind of a no-brainer. Law is a profession of specialists. So lawyer, okay, what kind of lawyer? And when I meet another lawyer and they say I'm a lawyer, the first question is, oh, what kind of lawyer are you? What area of practice? I don't know any generalists. I haven't talked to a generalist. I don't even know how years. Everyone specializes. Okay. Nobody's a generalist. Get an experienced lawyer. Probate is complex. Sometimes an inexperienced lawyer will say, yeah, we need to go to probate. And a more experienced lawyer will say, you know what? We don't need to do the full-blown probate. There's this other thing that we can do. That's why you need an expert. Certified specialist in estate planning, trust, and probate law is that expert designation. That is not necessarily the same in other states. California has that. And I'm a certified specialist. Fees are paid at the end. This is really important. Fees are paid at the end of a probate matter from probate assets, not your assets. So if there's a probate, and let's say it's a $1 million probate, and the attorney fees on $1 million probate are about $22,000, the executor fees are about $22,000, and there's maybe, I don't know, $5,000, $6,000 in costs, something like that, court costs and filing fees. That's how we get the $50,000 number. Those fees are paid at the conclusion of the matter. So it's not like you have to come up with this money and pay it to the lawyer to get the probate started. And if the probate lawyer says that, that's an issue. Okay, just in a probate context, that's another problem. But most knowledgeable lawyers will ask you, because they're not getting paid for maybe 2 years and they're having to do work and they're going to get paid 2 years later. Think about that. Most knowledgeable lawyers will ask you to cover, or what's called advance the lawyer money, to cover the filing fees, court costs, publication, and court mandated appraisal of the property. And I would say most lawyers are charging $1,500 and up. It just depends on the size of the bigger the estate, probably the bigger the number. But I would say that's kind of, if you're looking at going into probate and hiring a lawyer, you should anticipate that lawyer would ask you to front some of those costs, because you got to have a little bit of skin in the game. Look out, 529 education savings plans. We're going to wrap up our estate planning basics with 529. We'll take a quick look at this. And 529 plan is the savings plan for college typically, and now it's been expanded to school before college. But the idea here is you put money in and it grows free of federal, not estate, but federal and income taxes. That's an error. That should not be estate taxes, but it's free of income taxes. And how do you deal with the 529 really depends on how it was set up, and it can be set up in one of 5 ways. Now, a lot of people don't know this. You go, you get a 529. Okay. It can be very hard to change the nature of this account once it's set up. So it's very, very 5 different ways, and we'll kind of go through the 5 different ways of holding title. You can designate a successor owner, but not a successor beneficiary. If you don't designate anyone, it's a probate asset. So it's very important. So you can designate a successor owner of this account. And if you don't, it's a probate asset. And that's kind of an issue. So you can do an individual account. You can have it in your living trust. You can do an UTMA or UGMA. We don't see those too much. Minor owned accounts, we don't see too much. Joint tenant account, I would say we see the individual, joint tenant, and trust account the most. So here's the deal. If it's an individual, that means me. I set up 529, and we had 529s for our children when they were in college, and use those for college. Great. And if it's an individual, you own and control that account. You can use it for qualified education expenses. And this is a joint account is where 2 people, right? So individual, single, joints 2, and trust if it's in your living trust. Now, here's the wrinkle on this. With the trust account, the trust has to have the ability to hold the 529 account. So you need to make sure your trust has that provision. Again, this is one reason trusts are so long, and that's what is typically called a qualified tuition program powers. This should be in the trust. Custodian-owned 529s, meaning if it's owned by an individual or jointly held, they have no fiduciary duties to the account beneficiary, meaning the people who get that, who are named to get that money, and that can be changed freely. But the concern there is, if I die and my trustee, and I've got minor kids, and my trustee can change who gets that 529, I may not want that, right? I may want that. I don't know, but it should be addressed in the trust. Okay. You can grant the power to make additional 529 contributions. That should be in there if you want that to happen. And you can also limit the power to change the beneficiary. So that's 529s. And this brings us to the end of our materials. I will answer questions in just a little bit. Office locations in Northern and Southern California. We are in Montclair Village in the Oakland Hills, not Oakland itself. So, and kind of throughout the Bay Area in Southern California. Subscribe to our YouTube page and click the little bell and you'll get alerted to when we post new content, and you can stay up to date on stuff. And we have coming up, actually, if you're watching this on YouTube, you might have seen it before, just the way YouTube works. But next week, what if my spouse remarries? Protecting your kids after you're gone. Kind of cool, right? I will tell you, this is a running joke between my wife and I. She says, if you die, it took me 30 years to train you. I'm not getting remarried. She says, but if I die, oh man, you're going to be married in 5 minutes. So I'll just leave you with that. If you're watching this on YouTube, keep watching, because right after this webinar, or there's another one that's going to pop right up. Well, thank you, and we will see you next week.